So very good afternoon, friends. Warm welcome on behalf of Doctors Risk Medico-Legal Services, an organization which is fighting for the doctors from last 16 years plus, for their peace, for their calmness, so that they can give a justice to their patients. Doctors Medico-Legal Services is founded in 2005, friend, and blessed with a great team of advocates, medico-legal lawyer, and provided the services across the country, protected, defended doctors in every situation scenario, having a credit of 16,000 plus issues solved during this period, in which not even 0.5% has gone to the court of law. And if you ask me, the real reason, honestly I express, is just a sharing of knowledge with a doctor. I have found in all cases, my doctors are very good in their subjects. My doctors are good in protecting their people by providing a great treatment with their experiences, but they are not much aware about the law of the land. And that is the reason why this gets sufferings, they get suffered, people take advantage, antisocial activists, extortionists are always there to trouble them. And it's my personal experience. I found that if at all I can be a little support to my doctor by encouraging or giving us some knowledge to them, with my experience of my expertise in my field, probably majority of cases my doctor can handle by themselves. Majority of time they will be in peace. They can be a great supporter. So today we are going to have lots of learning when I talk about documentation. Dr. Shashi Kumar wanted to have some question. I don't know why they raised. Shashi Kumar, is there anything you want to speak? Because I'm going to take all questions answer at the end of the session. But still, if you got something, you can definitely go ahead, or we will take care of this at the end. So friends, in series of sessions, today we have decided to continue with the topic on documentation, medical record keeping. And this third session, I feel personally, we are talking on OPD papers, your own documents. On first session, I tried to emphasize with every possible litigation which is going to get raised because of your writing on a pad, with the various examples which I personally handled during the course of my practice and tenure. Last session, I have spoken very specifically on OPD paper. It has taken all the session. I know lots of things are still remained in that. But yes, we will cover in today's session. And today, again, I'm going to speak on various certification which we need to give during our regular practices, and how and what way we are safe, and how we can really make ourselves safe in such a scenario situation. I say so because writing plays vital role. In court of law, when I argue any matter, or opponent advocate argue, I have found that they interpret every word written on a paper. If he's an intelligent advocate, he knows how to win the case. As a defender, I need to really take advantage of your writing to prove our case. So writing plays very vital role. Why? It's not I say, it's various judgments of court of law says. Honorable Supreme Court in various judgment, Honorable High Court in various judgment has emphasized the importance of the most important part of writing. Written prevails over the oral. Written has got all the value. And various ratios of the judgment, which plays a very vital role as a precedent in a court of law to defend our doctor, can be connected to your writing things. Like a giving example, as it is very categorically said by the Honorable Supreme Court, that medical science is a complex science, and complexity of the same is beyond imagination of medical practitioner. Hence, in medical accident, even in the form of death, doctor must not be held responsible. But further, if you read a whole judgment altogether, because whole makes a sense, you'll find that very clear insight given this judgment. While protecting doctors is due care word. What it means that if due care has been given. Now, due care, if you ask me, we all doctor gives every possible care to the patient. In any complication, including the death, including the criticality, including simple drug reaction, being a doctor, we put all our 100% effort to save the patient or to provide the best treatment. We do everything by default, but we don't write it down on a paper. Now, in court of law, it becomes really difficult for us to defend you when there is nothing in writing, because oral does not have got a value. I'll give an example. You have advised the patient to do a sonography, or you have advised the patient to do a CT scan, or a simple CBC, where you have predicted could be a thrombocytopenia in a multiple fever or multiple days of fever, and patient does not come with the investigation back to you. And when you ask about the investigation, they very innocently say कि sir paisa nahi tha mere paas. Financially, we were not that affordable कि we can go for such an investigation. अब ऐसे scenario situation में आप तो कुछ नहीं करते हो, ट्रीटमेंट देते हो, उसके बाद अगर पेशेंट को कुछ कॉम्प्लिकेशन होता है, any patient dies, and they go to the court of law, relative, in court of law, they say that हमको advise ही नहीं किया था. Otherwise, we would have done. Now, if they have said orally this, and you have argued orally कि no, I have written, but they have not done, how you are going to prove? How it is possible for you to prove that you were right at that place? Because oral does not stand unless you write on a paper. उसी वक्त अगर आपने एक लाइनर लिख दिया होता कि patient, because of such a reason, is unable to do the investigation, we advise further, और सेफ्टी के लिए आपने उस पर साइन ले लिया होता. बहुत बार लोग साइन नहीं लेते हैं, कोई फर्क नहीं पड़ता, आपने ओपीडी पेपर पेशेंट को ही दिया है ना. कल को कोर्ट ऑफ लॉ में वही ओपीडी पेपर लेके आएगा वो, because he need to prove by some evidences that there is a negligence. But in OPD paper, which was a piece of a paper already with the patient, are going to be evident in a court of law where he is going to submit to the court. There we have got a good argument. Yes, it's mentioned there in same paper which is with the patient. It is not that I tempered having a record with me. If it is with me, I would have tempered. I would have written a letter. But taking a signature is a far wise decision. So, oral does not stand, friend. Oral does not stand in court of law unless been proven by the evidence. Yes, then we need to play lots of legal tricks to prove oral to be a right thing. But why to take such a pain when you got already ground to write things on a paper? Written has got all important in this country when I talk about evidences part. I get lots of cases across the country. I learn a lot of things. Your one writing thing on a paper, if you have remembered last time, I have given examples to you about the prescription where psychiatric drug written by the doctor used as a weapon of a crime by the patient for looting a people by dissolving the same medicine in cold drink and giving to the people and looting them, was troubled the doctor a lot. The question is not that you are allowed to write it or not. Question is that what quantity you are writing. If you have written in a very minimal quantity and the same prescription has been used by the patient on next time, which medical store are always there to dispense, you can be safeguarded yourself if your dates are there on a prescription. Most worst part I have seen in multiple times that even we doctor don't write the dates while giving a prescription. Write a date, write the thing. Last time I have shared this, how important is your prescription where doses, the quantity of doses, how many days, about follow-up plays a vital role in your prescription. So if you have written a prescription which is for only 3 days or only for the 5 days, patient had taken a medicine, letter not came to you, but used the same prescription to have again medicine for them, you can be safeguarded. But if dates are not there, you don't have any defense to say that this prescription was an old prescription or new prescription. I remember a case almost 8-10 years back came to me, suddenly flashed. There was a general practitioner who has been approached by the new married girl who came to husband's house recently, complained about stress, strain as she came to new house, sleepless nights. Regularly, few days she came to this doctor and feeling that she actually needs rest. This doctor has prescribed Restil tablet, 0.5 milligram, 1 HS at night, bedtime. Doctor has done without any intention, without thinking, only on the history given by the patient. And this girl was something else in their mind. Actually, this girl was having affair pre-marriage and wanted to get rid of the husband in newly married couple and wanted to go back to her paramour. She has used this tablet dissolved in a water or milk given to the husband. And when he fallen, slipped, she murdered, used that tablet as a weapon of a crime. I'm sharing all real stories to you. And then later made a drama that he died, relative came, in-laws came. They've taken to the doctor and finally it was gone for the postmortem. Luckily, no doctor has given a death certificate. Otherwise, this crime would have been suppressed. And in postmortem, it revealed that death is unnatural. And when interrogation was done, girl has admitted that she has done this. And my doctor was called by the police for the purpose of a statement. I know how and what way we handle the case because twisting can be done. Section 34 of IPC says common intention, where there's no intention of a doctor. We could able to do a justice to our doctor. But why I'm sharing this? Because your prescription is going to play a vital role. How and what way you have written. If it is written only for 5 days, 3 days, for 2 days or whatever, you can be safeguarded. So when you write something on a paper, you owe a responsibility of the same.